Marcus Whitfield was 42 years old, a commercial property investor who had spent the first 14 years of his working life managing other people's buildings and the last 8 buying his own. He had started as a facilities manager at a commercial property group on the East Side, the man who knew where every valve was, which HVAC unit ran warm in August, which tenant's lease had a clause nobody remembered until it mattered. He had learned buildings the way you learn a language when you live inside it, not from the outside, not from the description, but from the operational truth of the thing itself. What it cost to run. What it was actually worth when the deferred maintenance was accounted for. What a buyer was really getting when the surface presentation was set aside. He drove a 5-year-old Chevy Tahoe with 200,000 miles on it, and a portfolio folder on the passenger seat that held whatever he was currently reviewing. He kept a mechanical pencil behind his ear on site visits because he marked up inspection reports the way other people annotated books, not to remember, but to think. He was at a building or at his desk by 6:45 every morning. He was the kind of man who understood that the difference between a valuable property and an expensive mistake was almost always in the sentence of the lease that nobody had read. He had applied that same attention to his own holdings for 8 years, quietly, correctly, under a holding entity called No Properties LLC, that his wife Denise had never asked about, and that he had never hidden, but had also never explained. Because Denise had been, for most of their 9 years, interested in the outcomes of his work rather than its architecture. Denise had retained a litigator named Harlan Fossey. Harlan Fossey had a reputation for extracting maximum settlement value from high-asset divorce cases. He had a corner office on the 2nd floor of a building on Meridian Avenue that he had occupied for 6 years. He had no idea who owned the building. What happened when his own managing partner called him out of the pre-trial conference to tell him would be, in the measured opinion of Louise Tron, who had practiced real estate law for 31 years before she became Marcus's property manager, and who had made the phone call that started everything. The most complete professional correction she had witnessed in 4 decades of watching people fail to read the title. Before we jump into the story, comment where in the world you are watching from, and subscribe, because tomorrow's story is one you need to hear. The pre-trial conference was scheduled for 10:00 on a Tuesday morning in February in the offices of Harlan Fossey & Associates on the 2nd floor of 1180 Meridian Avenue. Marcus had known this since the conference notice was filed. He had known something else about it since the Thursday afternoon when Louise had called him and said, in the particular voice she used for information that was about to change the shape of a situation, "I need you to look at something." He had looked at something. And then he had sat with it for 4 days, in the way he sat with load-bearing information before he decided what to do with it, and he had called his attorney. And his attorney had said what attorneys say when the documentation is correct and the sequence is clear. Don't do anything. Let me handle the order of operations. He had been fine with that. He had always been a man who understood the order of operations. He arrived at 1180 Meridian 8 minutes early, not to go upstairs but to stand for a moment in the lobby, which he did when he visited any building in his portfolio, because he liked to check the condition of things without announcing that he was checking. The lobby floor had a crack in the grout near the east entrance that hadn't been there in October. He made a note. The light fixture near the elevator had a bulb running at reduced output. He made a note. He took the elevator to the 4th floor, where his attorney, a woman named Celeste Adair, had arranged for the use of a conference room in the offices of a title insurance firm that occupied the top floor. Celeste was already there. She was 52 years old, a family and civil law attorney with a practice built on forensic financial work. and she had the quality of someone who reviewed documents until she found the correct document and then built everything from it. She had a folder on the table in front of her that was considerably thicker than the one she had carried into their first meeting 6 months ago, and the thickness of the folder told Marcus something about how the 6 months had gone. "How are you?" she said. "Ready," he said. She looked at him. "You understand we're not going downstairs." "I understand. The managing partner is handling the disclosure. We file the conflict motion from here. The conference doesn't proceed until the conflict is resolved." She paused. "That resolution is going to take longer than this morning." Marcus nodded. He sat down. He took the mechanical pencil from behind his ear and set it on the table and looked at the folder Celeste had open in front of her. "How is Louise?" Celeste said. "She's fine," Marcus said. "She wants to know if you're going to send her something for her records." Celeste said, "I'm going to send her a case citation." Marcus almost smiled. He picked up his coffee instead. He had bought 1180 Meridian Avenue 3 years and 4 months ago. It was a 4-story commercial building, 2 retail tenants on the ground floor, 3 professional office suites on the second and third, storage and mechanical on the fourth, which he had converted to a title insurance firm's conference suite on a long-term lease. He had walked the building twice before making an offer, once formally and once on a Sunday morning in his own time. With a mechanical pencil and an inspection checklist, he had designed himself over 8 years of doing this. He had found 2 deferred maintenance items and 1 lease irregularity, and had used all 3 in the purchase negotiation to arrive at a price that was correct, rather than simply low. He had acquired it through Mowell Properties LLC. The LLC had been registered with the state for 6 years. The property had been recorded in the county's public records on the day of closing. Every instrument was filed. Every document was public. It was, in the specific and technical sense, information that was available to anyone who looked. Harlan Fossey and Associates had moved into the second-floor suite 14 months after the closing, a 3-year lease, executed through a commercial real estate broker, with a rental agreement that ran through Mobopple Properties Management Company, which was managed by Louise. Harlan Fossey had signed the lease. His signature was on a document that listed Mo Properties LLC as the lessor. He had apparently not looked up Mo Properties LLC. This was not, in Louise's professional assessment, an unusual failure. Most commercial tenants signed leases without researching the ownership chain of the entity they were signing with, because most commercial tenants were renting office space, not litigating against the building's owner. The oversight was ordinary in one context, and specifically, precisely consequential in another. Denise had retained Harlan Fossey 8 months ago. The retainer agreement had been signed in his second-floor office on a Tuesday afternoon in June, with Denise across the desk from him and a view of Meridian Avenue through the east-facing window. The window, the desk, the office, the building, all of it, at that moment, was sitting on Marcus's balance sheet. Denise had spent 9 years being the kind of spouse who occupied a marriage the way some people occupy a rental property, comfortably, without particular investment in the structural condition of the thing. She was not unkind about it. She was simply oriented toward what the arrangement provided, rather than what it required. Marcus had understood this earlier than he had acknowledged it. He had acknowledged it the way he acknowledged deferred maintenance in buildings he had decided to acquire anyway, not as a disqualifying fact, but as a variable he would have to account for. He had accounted for it for 9 years, and then, in the final 2, had stopped being able to account for it in a way that made the math work. She had changed in the last 2 years. The change had not been dramatic. It had been evaluative in the way he recognized the questions about the portfolio that arrived in a different register than curiosity. the occasional comment about what certain properties might be worth, the way she framed the phrase "our finances" in conversations where the word "our" had not previously appeared. He had noticed these things. He had written nothing in the inspection checklist he kept in his head for the marriage, because he had not wanted to write what the checklist would have said. In the 9 months before she retained Harlan Fossey, Denise had moved $29,000 from the joint savings account into an account she described, when Marcus asked about a statement he had seen, as a personal investment account she had opened on the advice of a financial planner. He had accepted this. He had not investigated it. He had extended the generous interpretation past its evidence, in the way he had extended it for 2 years in a row, because the alternative was the end of something he had believed in. The account was not a personal investment account. It was a joint account owned with a woman named Priya, who was Harlan Fossey's senior paralegal, and who had been, for approximately 11 months before the retainer was signed, a close personal friend of Denise's. The $29,000 had been used, in part, to fund the initial retainer payment to Harlan Fossey's firm. She had paid her divorce attorney, in part, with money she had transferred to his paralegal's account. This was the item that Celeste had found in the 4th month of her review. She had placed the bank records on Marcus's kitchen table on a Wednesday evening and walked through them with the same even delivery she used for everything, and Marcus had sat with the full picture of it for a long time before he said anything. What he had said, eventually, was, "Does Foss know?" Celeste had said she didn't know. But it creates a conflict regardless of what he knows. The question is when we disclose it, and in what order. The order had been determined by Louise's phone call 3 weeks later. Her name was Louise Tron. She was 64 years old, a retired real estate attorney who had left practice after 31 years to manage the operational side of a small commercial portfolio, which had turned into managing Marcus's portfolio specifically when a mutual contact had made the introduction 4 years ago. She was small, precise, with reading glasses she wore on a chain that she put on and removed throughout any conversation involving documents, and an attention to recorded instruments that was the professional equivalent of Marcus's attention to inspection checklists. Nothing got past her by being unremarkable. She had been reviewing the opposing counsel disclosure when she saw the name of Harlan Fossey's firm. She had looked at it for a moment. She had looked at the address listed for the firm's principal office. She had looked at the address for a second moment. Then, she had put on her reading glasses and pulled up the lease file for 1180 Meridian's second-floor suite. She had called Marcus at 4:47 in the afternoon. He had been on a site visit on the west side. He answered on the second ring. She said, "I need you to look at something." He drove to her office. She had the lease file open on her desk beside the opposing counsel disclosure. She placed both documents in front of him without comment and let him read. He read. He looked at the name. He looked at the address. He looked at the lease. He set the documents down. He picked up the mechanical pencil. He set it down too. "How long have I had this building?" he said. 3 years and 4 months, Louise said, and he's been in the second floor for 2 years and 2 months. She paused. His signature is on the lease. Marcus looked at the 2 documents on the desk. He looked at them the way he looked at everything that required a decision, not for the first confirmation, but for the thing he might have missed. He found nothing he had missed. The lease listed Mo Properties LLC as the lessor. The public records showed Mo Properties LLC as the owner of record. Harlan Fossey's name was on the lease. The conflict was complete, documented, and verifiable in under 10 minutes of title research. "Who else knows this?" he said. "You and me," Louise said. And now Celeste, if you call her. He called Celeste from the parking lot. She picked up on the first ring. He told her. She was quiet for 5 seconds. Then, don't do anything. I know. This changes the order of operations. I know, he said. What's the sequence? She told him. He listened. He wrote 3 things in the portfolio folder. He drove home. He made dinner. He did not call Denise. He did not alter his behavior in any visible way for the 3 weeks between Louise's phone call and the Tuesday morning in February. He was a man who understood patience as a structural element, not a temporary condition. He had built 8 years of a portfolio on it. He could wait 3 more weeks. He didn't move fast. That was the part neither Denise nor Harlan Fossey had accounted for in their respective estimates of him. Denise had described Marcus to her attorney as organized and detail-oriented but not sophisticated about the legal side of things. A phrase she had used, Celeste later told him, in the initial consultation. Fossey had taken this characterization and had done what confident attorneys do with a characterization that flatters their position. He had relied on it without checking it. He had not checked the title on his own building. He had not cross-referenced his new client's husband's name against his landlord entity. He had not run a basic asset search that would have shown No Properties LLC in the state's business registry within 45 seconds. He had accepted his client's description of her husband and had built his approach on that description, and the description had been wrong in the specific way that mattered most. Denise did not know the full architecture of what Marcus had built, because Marcus had built it in the space she had never examined, and she had not examined it because she had not thought it was worth examining. He's got nothing outside the joint accounts. That was what she had told Fossey. That was the foundation the approach was built on. The foundation was wrong. It was wrong by 8 years and 7 properties, and a holding LLC whose name was on the lease Fossey had signed with his own hand. Celeste had filed the conflict motion at 9:47 on Tuesday morning, 13 minutes before the scheduled conference. The motion documented the ownership chain, Empecaful Properties LLC, Marcus Whitfield, managing member, registered with the state, recorded with the county, publicly available, and the tenancy relationship, Harlan Fossey and Associates, second floor lease, 2 years and 2 months, No Properties LLC as lessor. And noted that the opposing counsel had executed a financial agreement with the respondent's entity while simultaneously representing the petitioner in a proceeding against the respondent. The motion was served on Fossey's firm at 9:49. At 9:51, Celeste received confirmation of receipt. At 9:58, 2 minutes before the scheduled conference, the managing partner of Harlan Fossey and Associates knocked on the door of the second-floor conference room where Fossey was preparing with Denise and her documents, and asked to speak with him privately. Marcus was on the 4th floor when this happened. He was sitting at the conference table in the title insurance firm's suite, with his coffee and the portfolio folder and the mechanical pencil, and Celeste was beside him reviewing the sequence of what came next. And Louise was on speakerphone from her office because she had asked to be present in whatever form was available, and Celeste had said yes. At 10:03, Celeste received a message from Fossey's managing partner. She read it and looked at Marcus with an expression that contained exactly the amount of satisfaction a professional of her experience permitted herself. "He's withdrawing," she said. Louise, on the speakerphone, said nothing for a moment. Then, "Of course he is." Marcus looked at the portfolio folder. He thought about a lease with a signature on it. He thought about 45 seconds of title research. He thought about a phrase, "He's got nothing outside the joint accounts." He had 7 properties outside the joint accounts. He had held them for an average of 5 years each. They were all correctly documented, correctly recorded, and entirely, irrevocably his. "What's the sequence from here?" he said. Celeste told him. New counsel for Denise. Mandatory disclosure waiting period. Rescheduled proceedings in which the full asset picture, No Properties LLC, 7 properties, the portfolio valuations, the management income, would be presented to the court as the actual financial record, rather than the description a client had given to an attorney who hadn't checked. The sequence was clear. It was also, Marcus understood, going to produce a very different outcome than the one Denise had designed toward for 14 months. The $29,000. The paralegal's account. The retainer funded through a transfer that created a conflict in the case it was paying for. That was the item Celeste had held in reserve, and it was not going away because Fossey had withdrawn. It was going into the new proceedings as a documented exhibit. What it meant for Fossey professionally was his managing partner's concern. What it meant for the proceedings was Celeste's. The paralegal item, Marcus said. Goes in the disclosure, Celeste said. It's material to the asset accounting regardless of who Denise retains next. She paused. She should have told her attorney. She didn't. That's not a problem I created. Marcus nodded. He picked up the mechanical pencil. He looked at the portfolio folder. He wrote 2 things and capped the pencil. Louise, he said. Still here, she said from the speakerphone. The grout crack near the east entrance. Can you get the facilities team on it this week? A pause. Then, from the speakerphone, a sound that was not quite a laugh, but was adjacent to one. I'll call them this morning, Louise said. It did not happen all at once. Denise retained new counsel in March, a competent, less aggressive family law attorney who came to the first proceeding with a complete asset search that showed MW Properties LLC in the first 10 minutes, because the first thing a competent attorney does is run the search. She reviewed the portfolio valuations Celeste provided and did not challenge them, because they were produced by a certified appraiser using documented methodology, and there was nothing in them that could be productively challenged. The proceedings took 4 months. The settlement reflected the actual financial picture. Denise's share of the marital assets was calculated correctly, from the correct figures, by people who had read the documents. It was not an unfair settlement. It was a fair one, which meant it was considerably smaller than the outcome Harlan Fossey had described to his client in the second-floor office of a building he was renting from the man she was divorcing. The $29,000 and the paralegal account were disclosed to the court as material to the asset dissipation claim. Celeste did not pursue it aggressively. She documented it correctly and let the court apply its own standard. The outcome added the $29,000 back to the marital estate on Marcus's side of the ledger. Harlan Fossey and Associates did not renew their lease at 1180 Meridian when the term expired 8 months later. Louise managed the vacancy, released the suite within 6 weeks to a civil engineering firm, and sent Marcus a 1-line email. Second floor is retenanted. Rate is 12% above the prior lease. You're welcome. He replied. Thank you, Louise. She replied. Run your own title searches. That's all I ask. He had been running his own title searches for 8 years. That was, in a precise and foundational sense, the whole story. He had 7 properties in the portfolio by the time the proceedings concluded. He added an 8th in October, a 3-story mixed-use building on the west side that had been sitting in an estate for 2 years while the heirs argued about the price, and that Marcus had walked twice, both times with the mechanical pencil, finding 4 deferred maintenance items, and 1 lease that had been running month to month for 11 months because nobody had noticed. He made an offer. It was accepted. The documentation was completed in 2 weeks because he and Louise ran a clean transaction and Celeste reviewed the instruments, and they were correct the first time. He answered every call the same day. He was at a building or at his desk by 6:45. He kept the portfolio folder on the passenger's seat. He marked up inspection reports. He read the sentence nobody else read. Agnes, Louise, every person who had ever worked for him knew that he read the sentence nobody else read. That was the job. That was the whole job, done correctly, which was the only way he knew how to do it. On a fall morning 14 months after the Tuesday in February, Marcus Whitfield stood in the lobby of 1180 Meridian Avenue and looked at the grout repair near the east entrance, which Louise's facilities team had completed in March and which had held correctly through 6 months of foot traffic and 1 wet season. He crouched beside it for a moment the way he crouched beside anything he needed to assess properly, not from standing height, from the correct distance. It had held. He stood. The building was quiet at 6:52 in the morning. The ground floor retail tenants wouldn't open until 9. The engineering firm on the second floor came in around 8. The title insurance suite on the 4th floor was already lit. They ran early, which he respected. He could hear the building doing what it did, the HVAC coming to temperature, the elevator running through its morning cycle, the particular sound of a structure that had been maintained correctly and was therefore doing its work without announcement. He thought about a Tuesday in February and a 4th-floor conference room and a speakerphone and Louise's voice saying, "Of course he is." He thought about a lease with a signature on it and 45 seconds of title research that hadn't happened, and the specific structural irony of a man building a case in a building he had never thought to look up. He thought about 8 years of learning buildings from the inside, what they cost to run, what they were actually worth when the presentation was set aside, what a buyer was really getting when someone finally read all the documents. He thought about the sentence nobody reads. He had built the portfolio on that sentence. He had maintained it on that sentence. The portfolio had, in the end, maintained him, not dramatically, not as a weapon, but as the simple, accurate record of what a man who paid attention had built while no one was watching. He took the elevator to the 4th floor. The title insurance firm's office manager was already at her desk. She looked up when he came in. "Mr. Whitfield," she said. "Early one today." "Always," he said. He sat at the conference table and opened the portfolio folder and began to review the inspection report for a building on the west side that needed a second look before the contract language was finalized. The mechanical pencil was behind his ear. The coffee was in his hand. The morning was doing what mornings do when you arrive before the noise starts. It was still and clear and entirely his. He began to read. I hope you enjoyed that one. Be sure to like the video and subscribe so you don't miss the next story. I've picked out 2 more for you that I think you'll really like.